covered utility patents, design patents, trade secrets, copyright. Only 2 more to go. Trademarks and contracts. So we're going to talk about trademarks. We're going to talk about the different types of marks, the forms of marks, the strength of marks, how you perfect rights and trademarks. So types of marks. There's, for our purposes, 2 basic types, a trademark and a service mark. And what's the difference? Trademarks are for goods. Goods, like Kodak cameras, Coca-Cola. Service marks, they're for services, like Bank of America. Does Bank of America have any product? No. I mean, their name doesn't appear on the money they give you. That's a service. Kodak Film Developing Services, when there was such a thing. That was a service. So a word can be both a trademark and a service mark. Kodak brand cameras, trademark. Kodak Developing Services, a service. A tricky thing is a trade name is not a trademark. So Kodak Inc. is the name of the company. It's not a trademark. Trademarks are adjectives. So it'll be Kodak brand cameras. If you can put the word brand after the usage, you know it's being used as a trademark or service mark. National Notary Association brand notary training. But if it's like National Notary Inc. or Southern California Edison Inc. or Kodak Inc., that's a trade name. And the reason that is an important distinction is you can register trademarks and service marks with the U.S. Trademark Office. You can't register trade names. So if you're trying to get trademark protection, it's important to use the term correctly. So let's talk about different forms of marks. Words. Ivory for soap. Surnames. Gallo for wine. Otis for elevators. Geographical terms. Atlantic for a magazine. Those are all very fine trademarks. Letters. IBM, ABC, CBS, NBC. All are good marks. Slogans. We try harder. That was Avis. They aren't trying hard enough, though. They used to be number 2, now they're number 3. But that's an example. Enterprise has gone by them. Symbols, like the Planter Peanut guy. That's an example. Color and color combinations. One of my favorite cases involved pink for insulation. When I was a little boy, I lived in Connecticut, and I remember putting insulation up in the ceiling, which was necessary, and had gloves on and everything, and the insulation was pink. And I grew up thinking insulation was always pink. Well, no, it isn't. It doesn't have to be pink. Owings Corning intentionally has their insulation pink, and they consider that a trademark. So if you buy pink insulation, it's from Owings Corning. Sound, like when you turn on your computer and you hear that Microsoft startup, that's a trademark, or the old NBC ding-dong thing. And actually somebody registered smell. For some reason they gave a flower smell to yarn. Why, I don't know, but they actually registered that as a trademark. Who makes those motorcycles? Harley Davidson. I guess they have supposedly a distinctive roar to their engine. They tried to register that as a trademark, and they got shot down. Trade dress and product configurations. That is what the product looks like, or the shape of the packaging. For example, if I had a Coca-Cola bottle in front of me, the old figure 8 bottle, and just held that up, and you couldn't read the label, you'd know that was a Coke. Or a Perrier bottle. Okay, you're probably saying, boy, Jeff, why is the wine here? Is this going to be a present? No. Without discussing the merits, these people think these people are infringing the trade dress that they claim they have in this bottle. Okay? So just an example of a trade dress claim. You know, I mean, if the case were over, we'd share the bottle, but it's not. So yeah, got to keep it. They're exemplars. It's great being an IP attorney sometimes. You get wine showing up in your office. Okay, I'm going to give you some real examples. These are some registrations we've attained in the past. Public storage, the words, but also you have the letters, PS, and then sort of that overall design, like Pink Panther. And that was one reason they actually were able to persuade the courts to give them the trademark registration, saying, look, we tie in pink, we advertise ink, and we've got a license deal with the Pink Panther. Here we go, Coca-Cola. So you have the word mark, Coca-Cola, and you have the bottle shape. Strength of marks. How strong is a trademark? Well, everybody wants a strong mark. And the best are fanciful and arbitrary terms. What's arbitrary? A word that really has nothing to do with the product. Like Atlantic for a magazine. It's fairly arbitrary example. Fanciful is a made-up word like Xerox. It never existed. As soon as you heard Xerox, you know that the first time, that's got to be a trademark. It couldn't mean anything else. It doesn't have anything else. Arbitrary, if I called that chair Decker. Okay, well, I mean, it's got to be a trademark. The word Decker may exist in the English language, but it has nothing to do with chairs. The next, which is not quite as good, but still strong, is suggestive. Bufferin is an example. Sort of suggests buffered aspirin, and that's what it is, but it's suggestive. The weakest are descriptive in surnames and geographic. They start off weak, but I mean, they can get strong, like Gallo. Initially, when you first saw Gallo, I said, oh, that's the name of the guy making the wine. That's not a trademark, but with a lot of use, it becomes a trademark. Otis for elevators, Westinghouse for air brakes. Geographical terms fall in the same category, and descriptive terms, things that describe something about the product. Like example, running into in the trademark office, we have an application pending for Euro quartz for vanity tops. Well, the examiner wants to know, well, do these arrive, or are these coming from Europe? Is the Euro part descriptive of the geographic origin of the product or not? Actually, they come from China, so they're not. And the last category is generic. Examples would be escalator, brassiere, elevator. One thing those three terms have in common is once upon a time they were good trademarks, but they became generic. They became the generic common name of the product, and therefore they're not protectable by anybody. So if you came into my office and said, I want to register car for automobiles, you can't. It's the generic term for them. So those aren't protectable at all. So the best are the fanciful and arbitrary, followed by suggestive, and then the descriptive, surnames, and geographical with enough use in advertising can become good marks. How do you perfect rights in trademark? Use is the key under U.S. law. We'll talk about registration, but you actually have to base your rights upon use at some point. So here's the preferred process. Do a search. Is the mark available? Now there's two ways to do a search. There's what I call the quick and dirty 90% search, where you go to the Patent Office website and see what's there. And again, that's www.uspto.gov. The other quick and dirty search I like to do, as silly as it sounds, is Google. See if, put in the mark in the goods and see what pops up. Assuming that's okay, then there's commercial search services that will provide a report like this thick that we use where it's important, and they'll check common law uses, the state registrations, the federal registrations, internet uses, and they'll come back with a report and those get analyzed. If the mark looks available, we generally file what's called an intent to use application, which sort of reserves the mark. Say, I have a bona fide intent to use the mark for these goods, and that will go through the trademark office, and hopefully it will get allowed. And once it's allowed, you prove use and you get your registration certificate. And then you have to renew that, and after a certain amount of time, if you're the only one using the mark and you submit a declaration about that, the registration becomes incontestable. So it's your mark. It can only be canceled for limited purposes, like it's generic, for example. If you registered elevator, and even though if it was incontestable, if it became generic, you're out of luck. So that's how you get rights in trademarks. And that's it for trademarks. The way to avoid infringement is don't use somebody else's trademark. The test is likelihood of confusion.